Well, when he appeared before Parliament early this week, Interior Cabinet Secretary Fred Matiang'i said he had never received any court order compelling him to appear in court or compelling the police to take certain actions. Yet the minister appeared to be contradicting himself because in the same statement, he said that in its attempts to allow Miguna Miguna back into the country, the ministry was following court orders as per the judgment of the High Court Judge Chacha Mwita. So, when then can court orders be deemed to have been served? And how can you serve seemingly unreachable members of the society? NTV's Andrew Ching has more.
On page 39 of today's Daily Nation newspaper, there is a paid advertisement published by a law firm, Mutua and Company Advocates, addressed to one Timothy Njihia. It notifies Njihia that he has been identified as a party to a suit going on in court and that he should hire a lawyer to represent him in the matter. The advertisement further states that if he doesn't do anything within 21 days, then the case will proceed without him. Such is the advancement of service of court orders, unlike what used to happen in the past before the enactment of the 2010 Constitution.
That was the old regime, where personal service was of utmost importance, where you would have to swear an affidavit that you actually served the contemnor with the order, and that he accepted or refused to accept service of the order. But that was in the old days.
That, it would appear, is the notion held by many senior government officials who often claim that they have not been in receipt of court orders, including Interior Cabinet Secretary Dr. Fred Matiang'i.
We have not been served with any court order, and therefore we cannot be contemptuous of an order that we have not been served.
Often, however, it has been almost impossible to personally serve senior government officials or departments with court orders compelling them to take certain actions and get a signed note or stamp confirming that the order has been received. LSK President Alan Gishuhi says that with the new constitutional order, things changed.
If you had a lawyer in court who was there and was present when the order was made, that is deemed sufficient service. In fact, in the West, I think in Hong Kong, some orders have even been served through WhatsApp, by the way.
Yet, even with these services, the person for whom the order is meant could always argue that they did not see the orders published, or were not in court, or were not able to see any of the proceedings in any media platform. Last year, lawyers representing NASA supporter Jimmy Wanjigi obtained court orders compelling the police to leave the home of the businessman in Muthaiga. They could not reach the Inspector General of Police and instead plastered the orders on the gates of the home, hoping that the police there would see them and move out. They did not. When television stations belonging to 3 media houses were shut down by the government in January, it refused to obey court orders obtained by activist Okiya Omtata to turn them back on. The Communications Authority refused to accept the orders physically presented to them and kicked out Omtata when he attempted to post the orders at the gates of the office. The LSK president accuses government officials of giving excuses whenever they are challenged about such orders, even though their issuance was public knowledge.
As long as you have knowledge of a court order, it could be pasted on your building, and it's been circulated or it's been publicized in the newspaper, or it's been communicated in court in the presence of a lawyer. That is sufficient knowledge and service.
It is even more interesting for Dr. Matiang'i because not only was the government represented in the proceedings in court, when he appeared before the Committee on Security early this week, he admitted that when Miguna landed in Kenya, his ministry had done all it could to obey orders issued by Justice Chacha Mwita to facilitate Miguna's entry back into the country.
The Constitutional Court quashed the deportation order, demanded the order that we allow him to come back, and actually recognized that he had a Canadian passport because they ordered us to allow him to come back using his Canadian passport. And that's why we went to the airport and we hoped that he was going to give his Canadian passport to be stamped, which he refused.
Well, it would appear that the government received at least one of the orders and decided to implement it. Andrew Ochieng, NTV.